Startups make a lot of errors when they're putting together their compensation programs. A principal one is it's very convenient to hire people not as employees, which involves payroll taxes and reporting to the government, but to employ people as independent contractors. Unfortunately, the federal government doesn't, and the state governments don't agree that somebody is an independent contractor just because you call them one. And so you can find yourself with a tremendous amount of liability for back taxes. And on the independent contractor side, you can find yourself liable for employment claims you didn't realize you could be liable for. So that's another error that startups make, is they will often accrue for compensation that they can't afford to pay. Let's say the CEO wants to get paid $400,000 and you can only afford to pay him $100,000, and they've accrued that $300,000 on the books. The problem is that there's a law called Section 409A that prohibits you from having a deferral of compensation unless you meet a lot of very tight rules. And ordinarily, startups don't know about this rule, and they don't follow those rules. A third thing that startups often run into is the failure to correctly classify employees as exempt versus non-exempt. Sort of the happy-go-lucky days, you'd show up and you were the secretary, but you would get stock options and you would get a salary and you'd be part of the team. The federal government and the state governments don't agree, however. Only certain people are eligible to be paid on a salary basis. They have most folks have to be paid on an hourly basis, and they have to be paid overtime, which is a classic mistake that these startups make, is they have everybody working overtime, a tremendous number of hours, but aren't paying people for that time, accruing a lot of liabilities for unpaid overtime. And then another issue that startups have is that they will fail to get their stock options correctly priced at the time they're being issued. In the old days, we used to think that there was a ratio. You'd say, okay, well, the preferred stock's worth X, the common stock is worth 10% of that. That doesn't work under current tax rules. And if your options aren't granted at a fair market value as determined really by a outside examiner, an outside expert in valuing stock, then you may have a situation where you've given people options that are subject to deferred compensation rules, and it results, when the employees exercise, in a 20% excise tax, as well as unpaid interest and penalties on those amounts.